I have just completed it. What is my judgment? It was there in my residence file. Has it come? With Justice Carter.
judgment
Go through my judgment and thereafter you argue. Yes, just find out.
Passed over. Item number 1 and 2.
Yes.
Item number 3.
That's my learned friend and we both stand on the same footing in item 3 or 2, 1, 2, 3, 4. So if we don't
1, 2, 3, sorry.
1 and 2, okay, sorry. I'm sorry.
We have called 3.
1, 2 passed over. Item number 3.
Which for the state by encroachment on the public road.
Miss Fortnight is appearing in this matter. Miss Fortnight is appearing in this matter on his, he's on his legs, on her legs.
Who is appearing in 3? Shukanti
Sahu.
Shukanti Sahu.
No name is appearing today. No.
Yes, pass over.
Yes.
Then next call for
Item number 4.
Niranjan Panda.
First one.
Just one. Okay. Let us see what is the prayer.
Yes, sir. Display.
One office to another office.
Hmm?
One office to another office. Construction of A&M sub-center.
ENM means
On the selected site, you have not constructed
you have not
the-
started the construction. Why you are keeping tight over the matter? That is what is the
You are not interested.
now she has
Yes.
come. Where is Mr. Niranjan Panda? Then we will dismiss all the matters. Why you are not constructing an ENM on the identified or
Selected site.
selected site? Why you did not ask for a? Why you did not ask for?
Actually, sorry, I am from the item 4, sir. That is a public indication pursuant to the notification made by the government for establishment of that A&M center in one village. That was there. Only for a direction that took the work to be proceeded.
Yes, what is this?
The last occasion instruction was sought for.
Study. Madam, what are you doing? This was filed in the month of January, madam, and service was affected much before. What is this going on? It's nothing. We are disposing of the matter, directing you to make a construction. Where is the order selecting the site?
Next one, sir, 4.
Sir, I have a.
Five, annexure 5.
Please tell me the page number.
Page number. Sir, page number 50. Annexure 3, sir. Huh? Page 15, annexure 3, item 32. Puranga, that is wrong.
No, that's one land required. Now, where is the land?
Land. Annexure 5, page 18.
No, for construction of a sub-center building. Why A&M? These are the sub-center buildings,
Yes,
not
sub-center.
A&M, not A&M.
A&M sub-center building.
There is nothing reflected from annexure 3 nor annexure 5. A&M word is missing.
Sir, 17, page 17. The CDM has
Page?
Go on to block number 6,
page 17.
page 32, sir.
Please. Page 17, a recommendation has gone by the CDM, the Chief District Medical Officer.
No, that is for construction of a sub-center.
Sub-center. That is
Sub-center means an A&M sub-center.
Yes, first paragraph.
After joint verification by the concerned RI.
A&M, CHO and NHM, that is National Health Mission, Bhadra. Proposed sites. for
So the
construction
last paragraph, the second site is Khata number 270, plot 665 for sub-center.
Odonga, 13 Odonga.
That's true.
That is a block of Bonth block.
On the block.
Feasibility report on site selection for substance building as in family welfare.
Page?
Page 28.
So feasibility report is also there. Then what remain? No. Though the instant repetition No, no, it has not been delivered. It's come on 3rd December. It's A, keep it in a seal and give it, don't open it.
For December 1 and 2.
Yes, both. Yes. Item number 5.
Regarding the irregular activity of Udit center matter. The head campus established about 14 years back. But that Anganwadi center is not functioning and they March 2024, the client fancy and the fusion of the locality have yet to the benefits of that on the website. The whole purpose of establishment of that center is being frustrated by the differentiated measures. And the report of the city bureau that is like
In view of paragraph 3, the PIL is not maintainable. If you are espousing your own cause, then it is not. It must be for the benefits of all the peoples. You'll have to say that these peoples are economically not so sound to approach the court, and you are espousing the cause of those weaker section of the society. Here in paragraph 3, you say that you are espousing your cause, not for any other purpose, any other persons. If not for any other persons, then it is not a PIL. We are dismissing. Withdraw. Very easy to say.
Item number 6.
Cause is a personal cause. Give a memo.
right.
May I please have? Right,
Yes,
is aimed at addressing some legitimate grievances involving larger public interest concerning the alarming and unchecked influx of illegal Bangladeshi nationals into various districts of Orissa, posing a grave threat to national security, law and order, and the socio-economic stability of the state. But I want to take the lordship to my synopsis number. I'm reading it out. This is an application.
what is this?
Pardon.
Is there any matter pending in the Supreme Court concerning
Not
this?
This regard.
No, whatever. There is a pending.
I have taken instruction this morning, Miller. Some matters are pending before the Honorable Supreme Court.
I believe I heard there is some matters which are overlapping.
And in another case, Miller, we have deported some of the Bangladeshi people to from Orissa. Thereafter, one habeas corpus petition is pending before the Honorable Calcutta High Court relating to that. These matters are pending.
Oh, you have repatriated to their to the country of their origin.
Special
Infiltration is something you are talking about.
What is my submission, my lord? In the year 2019, there was a notification of Ministry of Home Affairs.
True.
State is not acting upon it, my lord. That is my.
There is already a drive which has already been taken by the government in order to identify the peoples who are illegal immigrants.
Yes,
and have entered our country without any proper verified documents. I understand that. That is what a drive is going on.
yes.
In other state, I am aware.
Here, madam. Protect this own from illegal blasting of theft of the metal. I always partner of seven.
Still going, what is this metal?
Road
It
metal.
cannot be a metal.
Road metal. Road metal.
Road metal.
Road metal is big size of stone quarry. So that is
So
called,
it's 10 for metal. I really, I
that is called road, that is called road metal. In the
The railways, they use ballast as a specified size. The length of the tracks.
After the specified size, they turn it in their personal.
they mine it in a boulders form. It's a big one. And then they send it to a crusher unit.
There are.
And then of a specific size, it's crushed. This is what? So metal means what?
What is called metal?
Ore by virtue of many processes is converted into metal.
This can be getty, this can be pebbles.
It will get it, there is very small form of the metal.
Railways, they use ballast. This is ballast.
What is this?
And protein ballast or machine industrial ballast.
The stone quarry is situated within the reserve forest area that has not been put into action since last 10 years. But the opposite party number 7 to 9, they were establishing their stone quarries at the foot of the reserve forest area. They are illegally blasting the stone quarry situated within the
Sir, that is the quarry. If the quarry has been given to them, so
Quarry
they
has
are
not been
operating within the
quarry has not
quarry.
been put into action. Quarry has not been put into action since
Sir,
last 10
if
years.
they- This auction theory came only in, I think, 2015 or so. When? Okay. Before that, it was simple a settlement of the lease. And if the query is for a longer period and the lease is still continuity, the purpose, I think the auction has not taken place like this.
Not been put into action.
Why?
It
If
is
the lease is continuing, which was granted prior to this concept of auction being brought,
from the RTA, the petitioner came to know that the stone quarry is situated within the reserve forest area.
then you have not made it. You say at the foothill of the reserve forest. And now saying within the reserve forest, then what is correct
No.
statement?
The stone quarry is situated within the reserve forest area, but the
How can it be? How can they give a query? Then why you did not raise its operative since many years?
but the crosser units are situated at the foot of the reserve forest area, and stone quarries are situated within the reserve forest area. And stone quarry has not yet put into action since last 10 years.
I am
from
asking
the
you,
RTA.
sir, whether there is any inhibition or an absolute prohibition that the natural resources cannot be extracted if it comes within the forest area.
Yes, sir.
If the permission has already been granted,
There is no permission.
how do you know that there is no permission?
From the RTA application, the information.
That is what the information, is it sacrosanct?
Yeah, information,
RTI information is sacrosanct, I am asking.
since it is
There's
supplied by
one
the
judgment which says not sacrosanct. Because whatever the available documents they. If. No, section 10 is the previous. Yes. No. There. Yes, sir. Absolutely a personal interest.
money from wife from 40 gas or something. Their wife supply to him.
What?
Belonging to third party information. That is there in the without initiating process of.
How can you, these are the privileged document, is a personal document, individual document belonging to it, exception under section 10.
Still, we have seen that SOP. Yes, and item number 4, which is supplied to the.
How can you supply to it?
it?
And this is what the fallout of it
This one have already.
is.
Already.
The person of the arbitrary action. To the illegal conduct. And passed by.
What is this? What are these cases? To hear out and dispose of what?
Let's sit down,
In accordance with the principles of natural justice and RTI Act, what is this? What is RTI Act? That I know, sir,
Yes.
by this time. But hearing and disposal of under the ITI Act, I just wanted to know what RTI has to do.
Coming
My
under
lord,
PIL, but I don't understand.
That is what,
Sir, I.
Can you control the?
what are these?
Yes, yes, there are many instances where the court, the supervisor. I also that, let me. Yes.
Sorry, I'm sorry.
Yes. That's it, 10, page number 10, mine. Is the information given by the Orissa Information Commission that about 800 cases have been closed without any hearing. That is my defense. Page number 10.
To challenge that action, that's a public interest litigation. Is not.
800 people, there are many vulnerable people, pencil holders, they are students, they are farmers, they are workers, they are.
Have you indicated in your petition?
Yes,
Yes, show what, sir, above.
that is not indicated about 800 cases. Everyone cannot afford to approach High Court.
Oh, sir, you can't make out a case at the bar unless you have a pleading. You are arguing, divorce the pleading. Please tell us what you have stated,
Yes, ma'am.
please. Sure.
Ground C, ma'am. So more than 800 cases are already.
Grounds are the statement of fact or it is a submission.
They are including ma'am.
I am asking you,
Yes.
grounds are the statement of facts or it is a submission?
Both. Ma'am.
Okay,
Yes, ma'am.
I have not come to this.
Because fact is 800 cases are disclosed.
Sir, that is the ground.
That ground is the how it is contrary to the RTA.
Will you not state some facts?
Yes.
I am asking you, sir, you
Yes.
said many are pensioners, many are this. I just wanted to know how you have,
The
uh,
fact is my lord.
pleaded, how you have pleaded, sir.
4.2 man.
Yes.
How the case has been closed and
Oh.
arbitrarily dismissed without hearing. Total 114 number second appeal and 12 complaint case has.
Sir, if the peoples whose appeals have been disposed of without affording a hearing, then he must come forward if he is otherwise incapable. If he is capable to file a second appeal before the authority, then he is also capable to move a writ petition before this.
So second appeal cost nothing my lord, because it's in a before the second appeal before the Information Commission, it's only application, but for the High Court it is cost.
How much?
defer advocate minor.
If he can, if they can,
No, 800
Afford.
minors, only minors.
if they can afford, there also, there is no difficulty.
Otherwise, they are protected
Sorry?
by law.
Not-
Otherwise, 800 cases and without hearing. And the minor said, I want to.
So let them come before, let them say that without following the natural justice, they have done it.
They have already written, Information Commission in they have written.
So let them come, let them come.
Page 10, may I appreciate, page 10.
Let them come.
Minor 8.
It appears that they are espousing, they are capable enough to espouse their cause.
No matter, I am glad that to look into the Odisha Information Commission rules.
Sir, again, I am saying it is a public interest litigation or it is a regular writ petition
No, it is not.
seeking a warrant or seeking a
No, it is.
certiorari. I just wanted to know.
If my rod will, compared to
Why should you know your constitution? What is this?
But it's same.
and other courts are.
Yes,
Same issue as also raised before the coordinate.
That is not the same.
You also can listen, paragraph 6.
Yes,
Your justice assignment. You said that very same issue.
no, that is not same.
Exactly, sir.
No, minus. I have the counselor in that case.
And that can he control or
But it appears that that before the commission proceeds to dispose of the proceeding,
Yes.
they have intimated to each of them
yes, yes.
seeking their willingness whether they will
So that is
pursue
my.
or they will not pursue.
No, my in this case that should not happen.
Yes.
Yes, no. Because my not, 10 number 10.
But then
Get number 10 only.
in a PIL ambit
Let me speak.
you already spoken.
Let me speak, my lord. 10 on page 10, if my lord will appreciate. Total 173 number complaint cases, 86 number second appeal closed, disposed by SCIC. State Civil Enforcement Commission without hearing from 30 April 2025 to 4 July 2025. But in this way, how many, there are many state enforcement commission, they have documented. No hearing, nothing. Well, please reply my lord, page number 10. Annexure 1 series, 9 and 10.
Petition of that matter. If petition, can you find out whether this is a petition?
The repetition.
Only 1540.
The repetition annexure 1.
Give.
Commission has only stopped proceedings, willingness of the petition to pursue the proceeding or not.
Gosto mais só. Gosto mais de aí, ó. এই রেড পিটিশনটা মগেদের স্যাংশন ফটোটা নিয়ে যা 21/5/48
This is what is the difference. They wanted. Everything was, yes, that is. No, this is the difference with it. It was a richer one there.
call for that man soft copy.
So, sir, have you disclosed that on this restriction? You moved, I didn't know, my brother knows about this court more than me.
The matter.
You were the counsel,
Yes,
Yes, the matter of this.
no, that is the total separate ground.
separate grounds.
That is separate thing. Right? So they are replying so that these more cases are without hearing. That is the.
Sir, today if you do not appear,
Yes.
we'll dismiss it for default.
No, it is not
If a date-
without
Whatever.
hearing.
Without hearing means there was nobody to come and give.
No, it is not.
Sorry.
No date was fixed, no notices up to the complainant or applicant.
In the meantime,
No call list was prepared. So.
many people have got that information.
No, man. Only they are in person, they admitted that
90%.
they have.
Yeah, in
Can you glance at the only Odisha Enforcement Commission of Public Appeal Procedure,
maybe.
what is it?
What it says,
Section 6,
show us
provision,
the provision.
yes.
Where is the book?
Appeal.
Adeus.
Yes.
6, Section 6 provision, after surplus 4. Subsection 4 provision. Provided that the commission shall not reject the complaint unless a reasonable opportunity of the.
This is what they have already sent a letter to each and every person.
That is separate case.
It's a separate case. It says that it has been sent to everybody. Right.
That case.
Let's say.
This is
Sir,
separate.
what is your answer to paragraph 3 statement, first line?
Yes.
I dictated it just now tell me. First line, first sentence.
Petitioner is filing the present petition on his own and not at the instance of someone
What is the nature of the public interest?
else.
Espousing the cause of the many who cannot approach the court because of some kind of a disparity. If you are espousing your own cause, then
That is the rules, rules provide that. It should be reflected. That petitioner is filing also on his own. That is
yes,
the
you will
rules.
say, I'm looking at the rules.
Yes, sir.
Please. No, it will wait to. No. No, no. No. Public interest litigation. Yes. Big interest litigation. Because I come from a state where there are very, very strong words used in the public interest rules.
উঠাই দিয়ে উঠেছে Sì. Sentiamo. Posso.
When the newspaper report said that without hearing commission had
Sorry, you are relying that the various medias also publish the news.
Yes, yes.
So have you made a requisite pleading which is required under the rules?
Yes, the bidding matters.
Where is that regarding uh, just 1 minute. I'm just coming. I'm coming. Don't be so impatient.
For the point email.
No, I'm just. Rule 7 of the public interest.
Yes.
The Orissa High Court Public Interest Litigation Rules 2007. What is yours? Where is your statement regarding Rule 7?
So it's also. I have not solely based on news reports.
Sir, when you are relying, then don't rely.
No, I am not relying on news
No,
report.
no, you say-
Say.
Sir, please say. Well, what about 7? It says.
Yes, 782 solely.
Not solely what is not there.
If the petition is based on news report, but this petition is not
Yeah.
based on news report.
Why not?
Because
I have
I
included.
got the information from RTI.
Sir, para 5 you are. Para 5 of your claim.
Yes.
This
The source of information that there is based on information obtained from official record of Odisha Information Council. The petition also personally met the staff of the commission in office and requested them to take all cases for hearing and did not dismiss without listing the matter on board and hearing it. But the commission did not do anything for fresh adjustment of the matter according to the law. Various media also published that is my apartment. Various media I have not shown on the media.
Yes, on what basis?
No, I
The
have
media, they are not listing the matter, but the media has also indicated
Media has
that they have been, so it's not a foundation.
My foundation is based on written in paragraph 5. My foundation is based on information obtained, not media.
Media is the judge.
Yes, brother.
What you have written, see, various media also publish.
Yes, media also publish.
Regarding the arbitrary dismissal.
Yes,
Who will hold the arbitrary?
that is media report. Media reports.
How far is it to?
No, media report.
Thing as arbitrary.
I don't media reports.
No.
Yes.
There is that.
Media say that without arbitrary. No, I want to draw your attention to the previous letter relied by my senior. That is issued on 13th June. Before 100 of cases have been dismissed by without hearing by the commission. That report, that letter relied by my senior, it is issued on after June, June 2025. And a deadline was given August 15 to reply. But before that, 800 cases have been dismissed by the commission.
I understand.
Yes.
If he has done wrong, then the person whose appeals have been dismissed, let them come and raise a grievance. That is the public, we are more concerned on a public interest litigation. We are not concerned that what they have done. What is your right as a public spirited person?
Yes, my sincere submission, my lord.
That's all. We have heard, let us dictate the order.
My lord.
Go there. I think you have the another avenue somewhere else. Go
My
there.
lordship, I can get some another adjournment so that
No,
I can.
When the court has expressed the mind,
Yes,
is it-
I will give some adjournment,
that's all.
so that.
Public interest litigation. It's not a casual 5-paragraph public interest litigation. If you are banking upon an RTI, then in RTI you have to move before the regular bench for the purpose of any or a mandamus, not a public interest litigation. I just wanted to percolate that what is the distinction between a regular writ appeal and a public interest litigation. Here I find it is so intertwined and blurred. Everybody, a villager comes before the court, he becomes a public and therefore public interest litigation. Is this a law? I do not know.
Agreed person will give all the reason.
What aggrieved person? He should not be an aggrieved person. You are espousing the cause. For what? If you want, I can give you up to number of judgments which says that if any fundamental rights or a constitutional rights are invaded, then in that event, if they are unable to move to the court, somebody as a public spirited person may come for protection of those fundamental and the constitutional rights. It's not so easy that one will come and say that this action is wrong. You can go in the writ, seek for a certiorari, wash it. Where is the difficult?
But all should come because it was accessible. That is
Sorry?
the given.
Sorry, I can't.
Because I am about to picture person.
Withdraw.
We are about to.
Give.
Yes, of course. How are you?
Well memoed.
You have prepared and filed this. You have not prepared.
I just instruct. Just now I have instructed the officer.
You don't have to file. You have to file.
Yes.
You.
Yes, sir.
Item number 10.
The reappointment of Vice Chancellor
Huh?
Vice Chancellor of Odisha Agriculture University.
Odisha?
Agriculture University.
Agriculture.
The full, the appointment letter will annexed to. Take it.
How it has been done?
That is in violation of the statutory rules. In gross violation of the statutory rules, they cannot reappoint the incumbent when the term is expired. They cannot. Then the
Yes.
rules says below,
Please for notices to be issued to university. Notice. 2 weeks.
One you are approving. 2, 3, 4 notice.
Item 11.
This is a public intervention highlighting the site of a school where only 3 teachers, including the head teacher.
So the teacher people ratio is not matching under the right to education act.
It is in violation, not followed.
Who is for the? This is
Item 11.
What are you not doing it?
No, my lord,
The
I think-
Right to Education Act has already defined that what should be the people teacher ratio.
Yes.
For every number of the pupils, there will be one teacher. Why you are not?
No, it is there, my lord. An incorrect statement has been made in the writ petition. Lordship may kindly see the instructions that I have received from the block education officer
Then, sir.
and so also from the district education officer, my lord.
What do you mean?
There are 5 teachers.
So, wrong information has been given.
But there are
No, I see. They say that so far as you are concerned with Dhanaman Mandal upper primary school, he says that class 8 with the total raw strength is 112 students. And RTE says that 5 and as per the ITE norm, there are 5 teachers, 4 regular and 1 deputy teachers, 1 science teacher.
No, madam, this is not the correct fact.
What are you talking? These are the statements. Then put it on affidavit. They must by this week. Simple.
my lord.
Simple affidavit. Let them see.
My lord.
His current has some information.
in that monument, makes us very place to hide. So in spite of its, yes, ma'am. Yes, sir. Page 25.
You can just clarify. Here they file the requisition. There is direction to protect the monument. Then we have started construction of the boundary. Some hooligans and frustrated part of the boundaries. Then we have again, yes, again we have taken them. Their pair is there. As per section 30 of the SA, you have Monument Act, you have to take necessary compensation, all these things.
And split there. Because climatic relation in the decision, cannot be every shade stone falling down from the crown of the monument.
On that aspect, the SA authority, Lordship may come to the for a moment, we have lost the FAR. And after 5 days, the acceptance.
Disclose the facts. While you are disclose the facts.
Yes,
3 weeks.
3 weeks.
And that is.
Police station, fully mastered. After the advertisement, then the voice water treatment plant or the constructed by picture program. Under drafted council, for the supposed to secret to Benamigo, that's the adjacent residential area is 40%.
I could not make out the data tail from your prayer. What do you really wanted to say?
My association was the purpose I was to Ikura. In the doctrine example, those London doctrine of what we proposed to be set up after Benagigo, in so people was a district of Pullman. Near the 20 examples, and the number of villagers are suffering due to this construction.
What is the construction? They are constructing what? The water treatment plant.
Wastewater treatment plants.
So that is the very important thing that we have to get the water. We cannot waste the water. If there is a water plant, waste the waste waters. They are made drinkable water.
No, that is not
Usable for the human habitats. So obviously they are doing it for the larger public.
I am not opposing mind of not for construction. The area, as per the advertisement, but the picture that is in surrounding 4-5 kilometers, no residential area. But you look for us.
Potential of the water not there, you know how much it costs.
Now the proposed area, Benavilo is distant from the river Toya and Ganga Nara also.
This is not a river water, they want to make, this is not a direct water means.
Bhubaneswar city, Bhubaneswar.
This is making a usable water, so this is what is a very important factor now.
I just
Consumption of a water, I think which is a source of a life, without this the life cannot survive. So what is the difficulty? It is somewhere else. What is your river, then it should be very clear.
My grievance is that the proposed site is feature for. But without considering the public matter and no, there is no place.
What is the problem? It's some freedom. You do a public, a particular thing for a public or public, you went to the garden. Everybody there is a matter. Cannot confirm what I say, that it has to be done here, that you do the stage. But why the chosen, why that policy has been introduced? Your representative, who will be the mouthpiece of the locality where they are selected, he's there to be the mouthpiece. Decided that what is the
Government has decided to declare Pada.
whatever, later on, they may have, there may be a lot of research, there may be a lot of reports that says that it is not visible.
There is no reference platform, as per my demand.
What is your remark?
Pilots, that area which the petitioner is alleging, that area has, the proposal to make the switch plant, that area has been cancelled, my lord, because of the public protest and all.
So you, what more? So, what more?
I am not opposing, but I am thinking, better the suitable place to put up.
So there is a point, so there is a judgment, set up. So they have abundant this law.
Which is of the public.
They are not going to set up everywhere. But
Well, it's
this is very far.
a new area is, has been trying to find out a new place to construct the switch plant now, my lords. Near to the city, my lords.
Madam, the guideline has been playing because the NGP
Yes, my lord.
and the state pollution control boards. Now, if the public has come, people are continuing that we to go and use that guideline.
Well, this is what the instructions are, because there was a huge public protest at that.
The youth public protest, then the any care of that the public will take example. There's children, it's so far. There's no garbage to be able to run. Why you are so?
Initially, another area, this is the second area, my lords, and now they are trying to find out another area near to the Bhubaneswar city where the switch plant can be, as per the direction of the NGT, my lords.
Cancel.
Yes, my lord.
Cancel. Concern was that the effect is now the one of it. And they have cancelled it. So they are taking care of it. Will you proceed or will you discuss on that? The display that it has already been done.
Doctors. Please.
The instant public interest litigation is
ଭୁଲରେ ରିଭ୍ୟୁ ଲେଖାଯାଇଛି ସେମାନେ ଭୁଲରେ ରିଭ୍ୟୁ ଲେଖିଛନ୍ତି ମୁଁ ଦେଖିପାରୁନି ହଉ ଠିକ ଅଛି ବୁଝିଲା ପରେ SLP ହେଇଥିବ SLP ରିଟେବଲ୍ ଯାଇଛି ରିଟେବଲ୍ ଡିସମିସ୍ ପରେ ଯାଇଥିବେ
Item 14.
So it will again a fresh matter next day.
And you are telling my engineer there is a medical emergency.
Say that it's a fresh matter and that you have to. An exploitation is sought on behalf of the senior advocate at the
It's a PI mine. Residents of the Deogar
community health center,
community health center in place of the.
old district.
Yes, madam.
Is there any space? Is there any site which
Yeah,
can,
that way.
or whether it will cater, it will support this further infrastructure?
No, madam, the infrastructure wherein the old district headquarters hospital was functional. We are raising a demand for establishing a community health center in that premises once.
Do it, you go there, take. Thirty seconds to go through it. Where is this OCS RA rules?
OCS rules 1990
Please show us.
under
Because that is the only basis on which it has been done. So will you not show me that provision? I am not aware of the local the law. Please show us the,
OCS rule rule 1990.
please show us. I want to.
Definitions.
Now, that is what the court has single bench has held, but you do not come under the definition of a legal age.
And let's
Yes, one minute.
understood it quickly. Brothers also can be.
Sir, you have read it many a time. This is the first officer. Give me some time so that I can read carefully. The point is, okay.
When was the death?
That's on 26th April 2023.
23.
Yes, ma'am.
Then 1990 rules are not applicable to you.
20 rules.
When the death.
20 rules, brother, is not included.
No, which, when that,
Death my lord on 26th April 2023. And within 1 year he has applied.
20 rules will apply. Any total definition of
1990 rule.
2020 rules.
What is
90
the
rule will not be
Is
applicable.
there any other rules?
Yes, my lord.
Yes.
There is, yes,
Okay.
it also includes, I mean.
Another Vivaka. According to you, he is wrong. Judgment.
Is already.
You are a father?
Lord, I am the brother, elder brother. Of
Now
the
tell
deceased.
me one. But there are two appellants.
Yes, my lord.
Where appellant number one is the mother,
Yes, my lord.
and appellant number two is the father.
Brother. My lord, since a mother is
Right.
overaged,
Come on. The instant appeal
There is a provision that any of the family members with the consent of other family members, any of the family members.
Mr. Council,
One line, sorry. It is a cardinal principles of statute. The rules.
It rules 2020 my lords. Under my lords 2020 rule, there is a provision. Any of the family members. there is a
Sir,
provision.
you have not understood the second sentence which I said. It talks about the family members. It talks about the family members,
Yes, ma'am.
and the family member is defined, which does not include brother.
But here is a wider sense.
No, sir.
Especially if you are moving. Yes, my lord, we are informed the other side is there. Yeah. Yes, we have, yes. My friend appears for the employment consultant. We moved an application for improvement. And the, the respondents council are also present. You also permit me, I can address.
And the farmers in them in the protein.
That's a good sign.
No, I don't object. I support them. But so far the petitioner is concerned.
So this is item 33, in which I moved this item. 530.
What is the argument?
No, the appeal, your lordship have issued notice.
Yes,
Yes.
This is the intervening application.
That's right, Lord, it's an impeachment application on behalf of Winter Mines Limited Fellow. It's IA 4530.
And for the petition, appellate law, the lordship will recollect, this is that matter where I had applied. I had applied for a particular INCO plot.
You are not going into the.
Yes, it is that matter.
Then it will looking at whether he is the. He can.
That's
disobey,
That's,
cannot disobey.
Lord, if your lordship has the impugned order for a late fellow. Lord, if your lordship has a look at the impugned order.
I think the applicant will be very happy. Who is the applicant?
That's exactly what I was saying, Lord, the applicant could not be opposing, the one on the ground would go away.
It's.
So I am respondent. I'm also respondent.
Because you will get away with.
That's right.
Now,
Yes, exactly. In fact,
that is what.
one more
The very
aspect.
first sentence I read, I just thought that you will be
But that's in fact,
happy if they come.
yes, that's in fact,
That's exactly what
one more aspect I wanted to point out, your lordship had indicated that there was a case of a backdoor entry that was being provided. And now, Millers, after the writ petition was heard in extension before the honorable single judge on multiple dates, the blue-eyed boy never came. Now, Millers, the blue-eyed boy has finally woken up from the slumber and filed this intervention.
No, it was
Taking-
Already,
It's duty.
After the first hearing, that
It's
was,
duty.
it was after the first hearing before your lordships, seeing your lordship's intervention in this matter, they have now filed this. I may be permitted to file a reply to this intervention.
Only.
Not, Millers, insofar as they filed multiple documents. In their intervention, your lordship, with this application runs into 35 pages, the application, So, and they have made submissions on facts. I need to respond to that, only that.
No, so what I suggest is, if you don't permit me, Manoj, if the application for impeachment is allowed, we'll file a formal response to the appeal, Manoj, and place these documents on record. My friend can reply, Manoj, that instead of an impeachment application.
And so
That would be a better, Manoj, that would be the correct procedure in my respectful submission.
It may not be Millers that they have their application gets allowed and their submissions are taken on record without me having a right to oppose it.
You had an experience somewhere else as well. How the volunteers are. I have groomed in that atmosphere, but it's not a really.
Retapil is also very voluminous. We are repeating all documents of the writ petition have been filed.
The reasons are obvious. Make it voluminous.
We all stand in that shoe sometimes.
If your lordship will,
An experience somewhere else. That's why I just reminded you.
Because all I wish to submit is that my right to respond to the documents that they have filed.
Or in the additional application, to be consideration with what is the substitution. Whether they are the.
but if your lordship look at,
Appear when the single bench has cited.
Let them
they are the
intervene.
necessary party. And order 1 rule 9, they have a vote.
Order 1 rule 10,
Rule 10.
rule 10.
Order 1 rule 9.
Rule 9. That is what the party.
It should be a request for non-joiner of the necessary.
Correct, Lordship is right.
But 10.2 says that
Then
court can.
is the either to strike off the name or to add the power.
Add the power.
That's the power.
Right.
Which even can be applied for most.
That's one of my grounds also.
My friend should have impeded me.
your lordship look at annexure 20, but he knows that a right is accrued in favor of that party, but he did not prefer to challenge that.
I can argue in merits.
And after 24, then he has filed the writ petition. After 25,
That's not the case.
challenging annexure 25. So much thereafter, after 2 years, knowing fully well, nothing has been whispered in the writ petition regarding.
What is the normal period of limitation for us? Suit can be instituted for the same for the.
Yes, yes, not the Limitation Act, Article
If it is
137.
the limitation.
That is right.
Is the plaintiff required to explain?
It is required to explain.
And the correspondence is going on till October.
So the bona fide.
2024. Correspondence is going on till October 2024. Is it, should it be used against me that I was not trying to litigate the matter?
It is immaterial whether they are made parties or not. It is a discretion of the court also. You can delete them also. Not necessary.
What? Sorry, I took not.
Your lordships have also prerogative of considering while whether it is a necessary party or not party, that your lordship can delete.
Single bench has the dispense.
Yes, sir, that is right. That is.
What more, the judicial, because the judicial observation is sacrosanct.
Right, my lord. Right, my lord. But thing is that nothing to oppose. If they are made parties.
The only thing is the dispense.
Yes.
The grounds payment is dispense, then it is cited or limited.
Yes, yes.
If the party is heard.
Yes.
Because
That is exactly what I expect to say.
the
The lordship will kindly turn to the reply of the other respondents also, that is necessary. Yes, yes, the notice has to be issued. Notice has to be issued about the response.
This way have appeared. I have already appeared.
He's for IDCO. He's only for IDCO.
3, 4 and 5.
2, 3, 4.
2.
3, 4 and 5.
3, 4 and 5.
So 2, 6 and 7. Please do it within 2 weeks. Yes. Fine. 7 weeks. 20. This question I have from the 18th of 17 for 18. Today is 25th month. 3 weeks will expire on 16th. Yes. When is our not available to us campaign. They will try to take care of this. Yes, I also continue. Your logic keeping it subject to other number 18. Six. Right. Sorry.
Item number 18.
Where is the order?
Order dated 16/7/2020.
Yes, give us 30 seconds time. I am not aware, is there any provision, because in other state, there is a specific provision of apportionment of the family pension. So is there any provision of such nature here?
Here there is a provision 56(6). Odisha pension rule 56(6), where the family pension payable to more than one widow, the family pension is paid to widows in equal shares. This
That is what is also there.
is there.
Now you are saying that not legally married
Married,
and but she is a widow.
not legally married.
Social is a social security, the provision. Secure the family. What are you doing? You have to be very noble and model employer. Why you take so much?
Second marriage is taken place with substitution to past marriage. That is void. That is
She spent whole of her life with the deceased one. Now the pension and the first wife is no longer surviving. So
There
what
is also a
she-
decision of one High Court that reported
the
2002
first
one
one
whether
died, during the lifetime of your so-called husband or after?
2015.
What are it?
let it come day after
Who
tomorrow.
are you to decide marriage is valid, not valid, whatever? After all, she is widow. There is no denial that she married. Her marriage may be void. Her marriage may be illegal, whatever.
But in Rule 640, it said, two widows in one context, it has been said, that
This
is
is what I'm
to
saying.
examine.
These were the concept prior to the codification of the Hindu law. Prior to 1956. There was no embargo, there was no bar of more than one wife.
When custom allows, my lord, in that case, it is accepted.
No.
More than one marriage in a Hindu system.
It was recognized prior to 56. If you go, it was recognized prior to 56. It's only after codification of the Hindu law, the prohibition that comes. Hindu Marriage Act in 1955.
My lord, let it come day after tomorrow. Decision is referred to our own High Court decision is there. I have not gone through it, I just noted. Let it day after tomorrow, it will come.
Take a pragmatic view.
Yes, sir.
What?
No, the rule says that there are two widows, there are two.
But you are saying that she is not legally wedded, so cannot be regarded as widow.
That is
That is the whole thing. That's what I'm saying.
I'm saying, required a judicial review, because this act says the concubine no rights. So basing on the concubine is no rights.
No. Now, after this glossary of words, don't use this.
So that's why.
This says that this word should not be
Generally,
used.
what Rashid saying is absolutely correct. Suppose anybody is died and her wife should
I tell you, the word which you use is used in a different context, where there was no solemnization of the marriage.
Yes.
Here, the marriage was solemnized.
I'm not in there.
That is not, but the difficulty is that marriage is not recognized as a valid marriage in law. That's the only difference.
During subsistential farm, that is also second marriage was denied. During lifetime first marriage, that is also denied in the Hindu law.
Rule says wives.
Let it come day after tomorrow, I will go to the decision and clarify mine. On what context the rule 6 has been read up.
Then come on the next Tuesday, come with the
Yes, ma'am.
with this one, we'll consider.
Yes.
Adopt a pragmatic.
Yes. See,
Don't be so jealous.
Item number 19.
This matter relates to that suicide of that Nepali student in Kiev University.
What?
Suicidal death of a Nepali student in Kiev University.
In the meantime, investigation is over. In the meantime, charge sheet has been submitted, but investigation has been taken. And before that, let's see the prayer.
No. Prayer is that there should be committee for judicial inquiry. For fair and transparent. They wanted an SIT to be constituted. Now, once it has already been done, then what to do? What remains? There cannot be a second investigation.
The investigation is not on the track.
Whatever the judge will definitely ask for further investigation. There is no difficulty.
I'm not asking about further investigation. I'm saying
that is before the jurisdictional court. Where is that charge sheet or something?
That's the copy of the charge sheet is not available with me. But committee members.
There are larger issues involved, whether that post act is complied with or not. There are several
The
violations.
accused is arrested, Miller. Accused has been arrested.
Who has been arrested?
Accused. Accused person has been arrested, Miller. Charge sheet has been filed.
Arrested or not?
No, that is, sir, there are two aspects. of it. I tell you, what you are trying to do, say now, which is not reflected from your print.
In para 28 measure.
I am again saying, sir, there is an importance of a relief to be claimed in a petition. You may aver many things. But if you have not claimed the relief, then there will be a problem.
I know it's a PIL.
Again, I'm saying, you should. Now you are saying that I understand that this is what has happened. Now there should be a general directions where the adherence of all such statutory norms should be ensured by the state in all the colleges, in all the hospitals or whatever.
Yes.
I understand what you want. Why you did not? Why you did not?
Taken in paragraphs that these.
That will not do.
I will file an affidavit.
What affidavit?
Separate the institute of exercise is the party. I don't look at the role to.
No, there will be. If they bring an amendment, there will be.
Then they should include the eight institute of party in this case. They are not the main institute which place it was occurred. He's not a party to this.
Bring an amendment and that.
Yes.
Or return. Call the next.
Item number 20.
Thank you. In this word, the respect of mining affected district, government has decided to harm the honeybee bugs. And it is one district was it has completed Sundargarh and it is Keonjhar. Most of tribal is there, you lot of the bond was sanctioned, but it was not implemented. And you lot of
What are the ways, sir?
state is filed affidavit, there paragraph 5.
Twice the tender was floated twice, but it was a single bid. So it was a non-compliant bid, well, that was rejected. Then we sent it to the government. The director of industry sent it to the government that allowed the single bid. It was not allowed.
Huh?
Single bid was not allowed, twice.
I am asking, is there any agriculture or horticulture department which can definitely cater this honeybee or something of that sort?
But subsequently in 2022, the district industrial officer, he has put a requisition to the Odisha Khadi board and to submit the specifications. Now subsequently they will float the tender. That is what the affidavit
No,
says.
I'm just thinking in a different way. When twice the attempt failed, because there was no, I think more than one tender.
Yes.
Then the cabinet has its own department where you can definitely do all these things. Your own departments or your own fully owned or whatever, the partially owned companies.
The EIC has sought for specification to put the matter for third time for tender.
Probably either you are avoiding my query or you do not understand what I say. It happens sometimes that when it is not possible to have the adequate numbers of tender, then there is a government companies who can provide such kind of a thing. They have an expertise to do it. So sometimes for that you need not have to float a tender. They can straight away come and then provide because the government's initiative is the government work. That is what I am asking.
There are almost 4 agencies like Khadi and Village Industries and one horticulture
I
department
know,
is there,
I did the-
agriculture departments are there.
That is what I'm saying, the cottage home, the cottage home in the field where you involve the people, the local people there, what they are, all these things that can be done by you.
I think it's also in that regard, but whatever was there, whatever this is there.
Because what I find in other state also, the furnitures are required for because or something. So we do not find any competitive, the participants. And then there is a Forest Development Corporation Limited is there. They can manufacture, which is given to them, they supply the furnitures, chairs, and the wooden which has a sustainability, which can sustain for 50, 100 years. So it's the public money, so it's the best utilization has to be done. But next week you come, if there is any, you do it. You can take the.
Item 21.
Lord, this is that public interest litigation which I had moved regarding implementation of guidelines of living will. Lordship had issued directed Supreme Court guidelines. So they have to just follow. And this is the judgment. Lordship had already.
What you are doing?
I am from the opposite part number 2.
Who, you have left the living will or what?
No, no.
Who are you?
I am the registrar of this honorable court. It is the alleged against.
Why the registrar of this court is made
Because it is the direction of the honorable Supreme Court was to inform all the registrars of all high courts to
how can they implement it?
No,
Only
they will
thing
not
is that
implement.
they have to, they are
They will
messengers.
send it to the health.
Or I know they are simply a messenger. How can you make them a party?
They because whether they have sent it or not.
They have already said. Have you said?
Prevent the documents.
This, they have said, then what is the utility of them
Now
as a
question
party?
is now question, my lords, I will just read out the order. The registry will communicate.
I have seen this is
Yes.
what is quoted.
Yes.
All the respective secretaries, health secretaries,
Yes.
they have communicated it.
Then the writ application can be now the question is the health secretary has to implement. They have to form rules.
So that is what I am saying. Then why you are making them a party? You could have asked him what is there and you communicated with all.
Yes, that order was communicated. Your lordship had directed that whether you have made registry a party.
Now you are forcing us to exercise the advisory jurisdiction.
Your lordship may see the last order. Lordship may kindly see the last order. Right. Notice to opposite party number 2 by registered post.
We yet to receive.
May I please, your lordship, my item 23.
Lordship, no, lordship.
Next week.
March by the Lord signatures under Annex 11 is under challenge. Matter relates to a selection made for the post of Hindi teacher in the district of Nuwara. In pursuance of an advertisement under Annex 1.
Yes.
Before my friend starts, Melo, that's my difficulty. I was appearing for this petitioner in some cases. So I asked one of my friends to appear.
Not common.
No, it's a individual. So is that even related?
Not been offered for me to, I'll request my.
Next week, we are keeping in the meantime, you just. Any of them.
Right.
Or whoever.
Okay.
So this Hindi teacher, this same advertisement has not yet been settled. I have read many cases in single bridge also, division net
Yes,
also.
ma'am. Here, my lord, the only thing which requires to be interpreted by the lordship is the qualification required.
32.
Eligibility. What does it connote? Whether it, that is to be
Item-
only interpreted by the lordship.
Yes.
Item 32. Item number 32.
This is presented. Staff selection, non citizen or dated 17/2027.
Yes.
I take a look. That is related to page number 30. The case is related to recruitment. The both for junior data entry operator. It's a both when the advertisement of the distribution staff selection computer on the case of the requisition. At that particular point of time, the contractual rules of 2013 was enforced, which was actually subsequently repeated in the year 2022. So conditions which were prescribed in that particular advertisement, that is taking into consideration the conditions which are available in the rules which are in vogue. That is contractual rules 2022.
Sure.
Now, let petition of the lead petition of the for the non-secretary of that matter. On two accounts, he has stated that he has been debarred from getting the engagement because he secured 2 months less than the last surface of his catalog. And how we put that particular 2 months deficit, that on two accounts. One is, though he had actually put the question marks, attempted the questions, and we had also correctly answered, but those have not been answered, evaluated, and proper marks were not awarded. That is one. And the second is that because he is actually a holding a post on contractual basis, even though on outsource basis, he is entitled for 1 month each for the number of periods of service, years of service, in terms of that particular rule of 2030. So on the two accounts, he actually claimed that he ought to have been secured 4 months, but it has not been correctly. And
So what was your stand that yes, that question was evaluated or not evaluated?
Well, that is not.
I am asking a very simple question.
Yes,
You said that on these two grounds.
Now that has been answered, and that too in favor of the writ petition.
I am asking you, sir, you are challenging an order. What was your stand? What was your stand, whether that question was evaluated or not evaluated?
In fact, my lord, though we had taken the stand that it was properly evaluated, but for better appreciation of the same, Honorable Single Judge, my lord, he directed me, and I was also the counsel, to produce the relevant answer sheets.
Correct.
Not
So,
only of the petition.
so does it reveal that it was evaluated from the answer sheet?
No.
No.
And accordingly,
So accordingly, if you have not given a marks for that question, if you have not, then you have to give a marks.
yes,
So you gave a marks. Has he correctly answered that question?
yes, that
So
was
2 marks.
That
So
was
2 marks.
4 months, my lord, in that process.
Oh, he will get to 4 marks. Okay.
But my lord, the
other issue, my
No, just 1 minute. One by one.
my lord, only one.
Let me filter out.
I'm submitting in his favor.
I know, filter out. So 4 marks was given. So far as the prosecutor.
No, my lord, coming to this.
Second, suppose so far as if he is continuing as a contractual outsourcing employee, whether the advertisement, the recruitment when you started contains any clause for awarding 1 marks as a contractual employee or 1 marks or a 2 marks where he is in other employment in the government. What was there?
In the government.
In the government, not as a contractual.
No.
So that was wrong. So let us delete 1 marks. That is, but 4 marks are there.
My limited submission.
If he is 2 marks short,
My limited.
then he is already crossed the 4 marks.
Now my last,
He was supporting, I understood the moment he stood.
my last submission, my last. I think my last submission will clear the entire picture. Now, my lord, what single judge my lord actually answered in this case, my lord, while passing the judgment, that even though he answered in favor of the petitioner with respect to the addition of 4 marks, but at the time of final conclusion, my lord, there is only with direction only to calculate this contractual mark. There is no such direction to count this particular contract mark. Now, my lord, I am preferring your lordship in this case.
You go for a clarification if the learned judge has accepted.
No, my lord, because actually they should have, my lord, because
Why they should have?
my lord,
Because the ultimate decision was to award them or to put them in employment.
no, my lord,
What was the ultimate direction?
my lord, that is what my lord, I am taking your lordship to.
Shall be considered for appointment.
Yes.
Yes, sir. So,
Lordship,
so they were happy that they are getting.
Yes, my lord.
Oh, he wanted, brother.
That's that is why I don't want more.
Huh?
That 4 marks is
Not-
enough.
not-
That will also impact.
Yes.
That is.
That is why, my lord.
Second issue also say that.
Initially, I wanted to take your lordship to the page number 30, where the 2 issues were framed, and in page number 31, the first issue with respect to additional mark of 4 marks, my lord, that is there.
When entire reading of the judgment reveals that this there no.
Actually, I cannot say that, my lord, taking that.
You could have taken up for yourself.
What is that? Because they also didn't matter. But because it is, but there is no such direction, if the lordship will come to the last para, that to add this 4 mark. It is only with respect to this contractual mark. That is why, my lord, changed.
After awarding
And
the
if this
extra mark,
contractual,
it is
yes, sir.
and also it is found eligible. After awarding the extra marks
Yes.
to the petitioner.
Number 31, my lord, may I be permitted to read that one of the judgment?
No, I am looking at the paragraph 31, sir. Don't worry.
Yes.
I'm looking at paragraph.
I think this is very wrong. And the total mark of the calculated.
The instant appeal arises from a judgment and order detention. Next week, on the plate.
Entity model.
Item 36. 36.
Case for amendment here, amendment to the liquid. Amendment petition here also, I have also.
Yes, serve the copy.
Copy I already showed.
No, you have not given the annexure 11, you have annexed.
Annexure, I have made the way not the annexure to the amendment petition, the formal amendment. And
Sir, if your petition reflects annexure 11, but that annexure 11 is not given to them, we should give it. Or if it is wrongly written, then tell us that it is wrongly written in the plan, right?
you see, actually, it is not rated. It's proposed amendment. In the proposed amendment column, that annexure needs to be inserted. Proposed amendment. On the event the amendment petition allowed your lordship, I am having to also the annexing all the documents. Your lordship just have a class to do the prayer.
What is the amendment you want?
I want, your lordship, paragraph.
Where is the proposed amendment?
Proposed amendment at phase 4. Schedule of amendment, proposed amendment. At next phase 5 here. This para 30 may be inserted at
Yes,
para
yes. Oh, they wanted to bring it that it was, they are still continuing.
Well,
Then after the word Katak.
well, this paragraph may be added. Because after that, your lordship.
I've just come there.
Residential was also the colleagues are not agreed to that place, your lordship. They found that that petition is getting that encroaching. It's kind of impacted the degree and an order day. Particularly.
File your opposition to this. This cannot be, sorry, I cannot express, difficult. File your opposition. Now soon 1 week. 2 weeks. 2 weeks. Look here on.
Item 37. Yes, 9th. This. Item 37.
And file application for my market some.
Who is for the petitioner? You.
Status code of task I have already invested a huge amount, my lord. The size of EIL, my lord, the order of being vacated, my lord, because I received all the closures after.
Are you ready with the main matter?
In course of the
Last time they also taken time, my lord.
No, are you ready with the matter? Final hearing?
Today I not ready, your lord. Today I the rejoinder, your lord.
What rejoinder?
In their counter, your lord.
Yes. Final rejoinder, we are keeping this matter on the next week. We'll hear out this matter. Don't worry. It's next Tuesday.
Because the time will be expired, my lord.
I understand. Next Tuesday we are.
Item number 38.
Yes, still next Tuesday. Next.
Item 38.
The service, how many days delay? Have you filed your opposition? Have you seen the recent judgment? Judgment, yes. Order of the Supreme Court. In one of such group of matters, you went to the Supreme Court rejecting the section, will be rejected section.
That I have not received the copy of that.
Look at that order and say whether you oppose.
Around
That was 400 and something days delay. No, we gave all the judgments. And look at the judge order.
The civil judge order was confirmed before the hearing, right?
No,
The data entry operator.
no, there is another section 5 which we.
Let us come back.
Let us come back for disposal.
That was also.
No, it was authored. It was authored by me. No, I'm not talking. We need to say 4 or 5 days before this order is.
No, that was also, but Sunamandari case. We followed and we dismissed. We dismissed. It has come back.
I think the
Data is coming back.
Around
just go through that order. Well, first thing. From the court officer, you can get.
Item 40.
So, 69 days. Only have 269 days. 269.
Go through that judgment and then yes. I have tell you, I have in all these cases, the same grounds have been assigned to him. One of the matters they went to the where he considered all the judgments of the Supreme Court. Even a recent judgment, we heard that there is no plausible explanation. The apex court set aside the said orders only on the ground that the appeal was dismissed only on the ground of delay and not on merit. So the order is set aside. Consider the matter on merit. Will you now oppose the section 5?
May I suggest one thing, no? But I am the reach petition respondent here. I have appeared. But
You are considering for delay and
I'm
hearing.
just saying that.
Tell us.
Let them say, let them serve the copy so that along with delay, and also I have to raise the point of maintainability. Let it be taken up heart.
No.
But
Unless the delay is condoned, it has not borne. It has not borne.
Then next week, Wednesday.
Not Wednesday, Tuesday,
Next
is the
Tuesday.
date fixed
Yes.
for these matters. I have now fixed the date for each category of the matter. Next Tuesday will come.
Item 41.
Usually I
Item 40, there are 3 more matters challenging the same common judgment. I am sorry. You give me a list.
41. 41.
Item 41.
Hey, team not India difficult. Little common
Then next Tuesday week.
9th.
Next.
Item 41.
Legal has not been, objection has come. Discuss. How many days delay?
421.
Dismiss. Dismiss what is one. The application consequently will be. Next. Oh, I'm talking about this one. I'm talking about this one. No. Oh, I'm not talking about this order. Oh, now I got it. Good. This is the order.
Mr. Das.
This is all.
Mr. Das is the. You
Last.
This is the 41 order.
Watch.
So on merit, next week, none appears in support of the appeal. To give another opportunity, let this matter be discussed in the next week. We dismiss the section 5 and this is the latest order. Next.
Item 42.
Two chapter. And a fixed date for a.
You have fixed the date today, Argu.
I'm sorry, I filed.
The next week you come.
Yes, ma'am.
Next Tuesday.
Yes, ma'am.
Yes.
Item 43.
There.
You have got 78 things.
Will you oppose or
Yes, sir.
have you seen the latest order?
It is your WhatsApp document is there.
This has been set aside. This is a Damayanti. What is this? What is the name? Damayanti Patra. Is a Damayanti Patra case. Same order. Latest Supreme Court is 10th of November. There is no latest than this. Give it to him. It is a 421 days delay.
12 September 2021.
This is 11th and 10th November 2024. 5 days or 7 days before. This is what I am giving. Item number 41.
Right.
Today's item number 41. You will find the order. Next week.
Item 44.
Why? Condonation. You are very liberal now. No tomorrow business. This is the day assigned, then come on next Tuesday. Next Tuesday. Next.
Item 45.
Yes.
This is regarding that matter in arbitration. Arbitration award was set aside by the Great Court.
Oh, I have already delivered a judgment.
Yes, I have gone through that. The sun flag, the facts and circumstances of that case and the present case are different.
Why?
The reason being, the Lordship, here the arbitration clause was already waived by both parties. The Lordship, kind of. Yeah.
How
I'll.
have they subjected themselves to the jurisdiction
Yes,
of the
yes.
civil court?
Yes, sir. This is a data that I'm giving you. So I filed my counter. What has the counter?
Must be in the file.
Your Lordship, may kindly see that first yellow line is the civil suit filed by the opposite party. Okay.
The suit was withdrawn.
The suit was withdrawn after filing of my written statement, Your Lordship. After in 2019, Your Lordship. Why? What had happened? If Your Lordship has my counter.
What do you want in the counter?
No, counter I have stated there are two orders passed by this honorable court wherein the time period was not extended in 2017.
Time period means what?
Under section 29A, an application was filed by the opposite party, the appellant, wherein the court refused and did not extend the time period. Thereafter, the opposite party, as in me, I went and I pursued. I filed my Wakalatnama on 18/6/2017. That is 2017, if Your Lordship may kindly see. Thereafter, I filed my written statement on 28/9/2017.
No, that I have already read it.
Now, Your Lordship,
Issues were framed.
Issues were framed.
Then an application for analogous hearing of both the suits.
Absolutely, Your
But I do not know where is the other suit.
Now, the other suit is at green color.
Filed by whom?
Filed by me, Your Lordship.
Yeah.
And this was for recovery of possession.
There the section 8 was.
Section 8 was rejected and it has attained finality. Your Lordship, Supreme Court is very clear that
what happened to the High Court?
The High Court, those after three.
Suit is staged by the High Court in WP 2018. What happened to that WP?
That WPC was also rejected.
When?
On 10/1/2022. Because he
Then
failed.
an application under Order 7 Rule 11(5).
That was also rejected, Your Lordship. Both there is another one, recent one that was also rejected.
Now this suit, which suit was withdrawn? The earlier one,
The filed by the appellant, it was withdrawn.
Your suit is still pending.
My suit is still pending, Your Lordship. And Order 20, their suit subject matter and the subject matter before the learned arbitrator is the same. Identical prayers, and once the court has held that once Section 8 has been rejected, there is a principle of constructive res judicata, Anil versus Rajendra. And 8.3 also talks about that. If once parties have waived their right, it cannot be restored. This is what Goose Allen judgment says, Your Lordship.
Justice Ravindra.
Yes, Your Lordship. And it was recreated in other
A
judgments.
very recent judgment has been recreated.
Yes, Your Lordship. So now in this scenario, when once parties have waived, and the reason why parties had gone to civil suit, because in his own civil suit, Your Lordship.
What about the recent judgment of this Palanji, Sapurji Palanji's judgment of district party?
So that has not taken away the effect of when both the subject matter has not been referred under section. The only provision under Arbitration Act is Section 8. I haven't gone through, Your Lordship. I'll go through that.
Palanji is a respondent therein. Appellant name I do not know.
Right, Your Lordship.
Reported in 2025, volume 9S.
Okay. I'll go through that, Your Lordship. Here, what has happened is, I have already accepted their stand. Here, in this case, at para 32 of his suit, he has categorically stated that the arbitration clause is not maintained.
And what is the they approach the single bench?
I approached the single bench because the arbitrator didn't have any jurisdiction.
The writ jurisdiction you invoke.
I invoked the writ jurisdiction because, Your Lordship, there was patent lack of
what the writ court has said.
The writ court has set aside the order, but again has
What set aside the order passed by?
Passed by the learned arbitrator.
So arbitrator was appointed.
Arbitrator was appointed.
By whom?
By me.
By this court. by
By
this
this
court,
court.
section 11.
Section 11.
And then it says that you have waived the arbitration clause.
No, your lordship, after 9, there was another judgment. Once,
I am asking you, sir, you have taken me to a good detour.
right,
I would appreciate.
right,
It's a good detour. Come to the main point.
right, your lordship.
Arbitrator was appointed under section 11.
Yes, your lordship.
Arbitrator passed an award, the order.
Yes, your lordship.
The order is assailed by you in the writ petition.
Yes, your lordship.
Correct?
Yes, your lordship.
Now, tell me whether the writ is maintainable.
Yes, your lordship. The reason being because I don't have a remedy.
Can you now reopen the issues that you have waived your arbitration clause? You can raise this point under section 16.
No, your lordship, I cannot because
Now section 11, after section 11.
Yes, your lord.
How far you will go there?
I'll read. There is this SPB judgment also clearly
SPP Patel Engineering is still there.
Yes,
There is no difficulty, sir.
in that order, it has
Paragraph, it says that all these orders of the arbitral tribunal is not susceptible to be challenged under Article 226.
But it also says, your lordship, in that judgment, it also says that an order passed under section 8 by judicial authority cannot.
Sir, can you invoke? You can take a plea under section 34.
How can
when the award, that is
How
what the
can I
SPP
take the
says.
30? Because they were supposed to go under 37, your lordship.
Sir,
Once they have
that
failed
is-
that.
that is the SPP when you take. You
Yeah,
can't
I'll
make a
read
pick
it.
and choose.
I'll read the paragraph. you know.
Yes, and read that paragraph
I'll read
also
that.
which fetters
I'll read that
226 and 227.
Wait.
Which fetters.
Oh. I'm so sorry. I'm in immense pain.
No. If you are in pain, then you come. When you have a pain relief with you. Don't worry.
I'll show your lordship. This is
There are two things. Never argue while in pain, and for the judge, never dictate the order when you are in anger.
Right, lordship. Sorry, lord. I have been suffering from a backache since last 4 years, and it has aggravated. So I cannot sit or I cannot stand also. It may be because I'm going for a medical checkup. If it can be taken on 9th, I'll be organized.
It will be on the next Tuesday.
And next, because I'll be traveling for medical checkup.
No, you have a pain. Don't travel too much.
No, I'm flying your lordship to Delhi for medical checkup. So if it can be taken on 9th, that will be nice.
9th on Tuesday.
And in the meantime, I'll read the Sapurja.
Have you ever seen Mrityunjay Parak, sir?
So here is a case here also where parties have, once the parties are waived, they have not.
Oh, sir, section 11, why you did not resist?
That time,
Why you did not?
because I was
did
not aware of the
resist?
suit. I was not aware of the suit, your honor.
I filed a suit and you are not aware of the suit.
No, your
What are you talking about?
They have filed a suit. Your lordship.
Your suit, sir.
No, your lordship.
You said the green one is my suit.
My suit has been filed.
Oh, sorry, the red one is your suit.
No, yellow one is there. No, yellow one is there, your lordship.
And green one?
Green one is mine. I
So
filed
you
it
do not know in
after
2017 when you filed a suit,
2007.
section 8 application is rejected, order 7 June 11 is rejected. You are not aware.
No, this is my suit. I am aware.
No.
I am aware. I have filed my suit in 2017 once the court refused to extend the time.
You were aware that you have filed a suit at the time of section 11.
Section 11 has been, section 11 order has been passed in 5/11/2015, your lordship.
So that's
So
all.
I have filed it in 2017.
Then you go and take a plea before the arbitrator, or if you have taken that plea in the ground, section 34, you go and.
Your lordship, 37.
It does not. It does not.
37 is not. 37, they were supposed to go under 37.
No, sir, section 8, I understand. After the amendment having been brought because of Justice Nariman's judgment, previously section 8 was not available one.
And when I section 8 only, even in commitment. I'm sorry.
Wow.
I remember.
Section 8(3) is also clear if there is a pendency of 8(1).
When there is already an appointment of the arbitrator, that's enough.
No, your lordship, once the party waived.
You are in pain, come on the next week, you argue. on Tuesday.
Your Lordship, if it can be done on 9th, I
No,
will
no,
oblige.
no.
Because I will not
see
see
the
the
march over it.
9th. Your Lordship, keep it on 9th.
I know, I do not want 9. My own judgment is staring at this.
I will satisfy your Lordship. If, because I'll be traveling, your Lordship, kindly keep it on 9th. Keep it on 9th.
No, you were a part.
Yes,
It is a match. Yes.
Right, Your Lordship.
No.
It will be much difficult because I will traveling, your Lordship.
Don't embarrass.
I know, your Lordship, but I won't be able to recover, your Lordship.
Don't worry, you will recover.
Then I'll surely do it, your Lordship.
But it will kindly, the interim order, Malad, whatever it's worth, the interim order, Malad. Well, the interim order was, Malad,
The entire arbitral proceeding, you no understand what's
Yes,
interim order.
but your Lordship.
Just wait
No,
for a
it was
second.
there, Malad, that is.
So interim order, if it is there, then continue.
Two password matters.
Which password?
Password.
Which one?
Item number 3.
Malad, may I have one small thing, if your Lordship's permit, Malad. Malad, could I have, Malad, if your Lordship's permit, Malad, if this could be fixed at a time, Malad, if it's possible, at 4 o'clock, 4:50.
I tell you what we have decided from this week, that a particular category of cases will be taken up on a particular day.
Right.
Because what we find that the moment we mix up,
That's the,
then the situation becomes absolutely out of control. Some matters you cannot resist or prevent the council to stop in
Right.
arguing.
Right.
So that's why we decided that if one category, no problem. So these categories will come only on Tuesday. You definitely, we wanted this to be placed
Very
on
good,
Tuesday.
very good.
So Tuesday, it will be there at the fairly, at the top position, don't worry.
I'm very good, very good.
And it will be taken.
Your Lordship,
Next week.
Huh?
Next week it will be.
Next week.